It happens 100,000 times a year in America, according to the CDC. A pregnancy develops outside the uterus. It's called an ectopic pregnancy, and it's just the kind of crisis at the heart of the latest moves by the Biden administration when it comes to abortion rights in the wake of the latest Supreme Court decision on Roe v. Wade. As you just heard, California's former Attorney General Xavier Becerra, who now leads the U.S. Department of Health and Human Services, told all hospitals Monday that when a mother's life is at risk, an abortion should be performed regardless of what the state's new stance on the procedure is. Here to walk us through this delicate dance between state and federal authority is constitutional law professor at the McGeorge School of Law and former Supreme Court clerk Leslie Jacobs. Good morning to you.
Good morning to you.
When the president spoke out Friday as he issued his executive order on abortion, he acknowledged that he alone cannot do very much to reverse or mitigate the Supreme Court's decision to overturn Roe v. Wade. But yesterday, on the first business day after the order, here comes this edict to hospitals. Many of the states that had trigger laws ready to go if Roe was reversed, laws that would ban abortion in individual states if abortion fell federally, and that's about 26 states, had provisions in their laws that did not provide for any exceptions, even when the life of the mother was at risk. So what's at play here?
Well, to be clear, the president didn't issue an edict. What he did is he directed an agency under his control that manages health to issue a clarification of law that's been in existence since 1986. And so what we see in this clarification is it making about 3 points. Number one, this law exists and has been there a long time. What it requires, which is that emergency room doctors give emergency treatment that is required to people who walk through their doors. And what's always been true since the Constitution was written, valid federal law prevails over state law.
Now, if the Supreme Court decision that just happened is about kicking this all back to state control, how can the Biden administration say what it did? I know this is a reminder, as we talked about, with HHS being in charge of reminding hospitals of this, but it seems like state control was what the Supreme Court was really emphasizing with their latest ruling on Roe.
Yes, the Supreme Court was emphasizing that states can pass rules restricting abortion to the extent they have the legal authority to do so. But to the extent that the federal government has the legal authority to make rules that incidentally have to do with abortion, which is what's going on here, then federal law controls. So the point here, what the law requires, this was enacted in 1986, and the point of it is that hospitals can't turn away patients who show up just because they can't pay. Hospitals with emergency rooms must A, screen the patients for an emergency condition, and if the hospitals find them, then B, they must give that patient the treatment the patient needs to become stabilized. So if it incidentally is within the doctor's medical judgment that abortion is required to stop that emergency, then that's what federal law has required since 1986. This order simply makes that clear.
And the order that we're talking about, or the law that we're talking about, is EMTALA, and it deals with the emergency treatment. Now, I have to ask you, if a doctor is in one of these states that says, you know, we have no exceptions, and this federal law that's been in place since 1986, this reminder has gone out, and they decide to go ahead and perform what they consider to be a life-saving treatment in the moment, does the federal government have an obligation to step in and protect them if the state tries to go after them?
No, the federal government wouldn't have an obligation to step in. The point is that that person, the doctor, would be able to raise federal law as a defense. So this isn't a panacea for doctors who currently, their problem is that actually all states, to my knowledge, still have an exception to protect the life of the mother. But the problem for the doctors is that when the pregnant people come in, it's not usually 100%, oh, for sure she's going to die. It's a risk assessment. And it's, do we wait longer? What treatments are available? Which ones are the best ones? And how much risk should we tolerate? And so what this law makes clear is that to the extent that it applies, which is to emergency room doctors, then the federal rule that the doctor's judgment controls applies, and that should give the doctors some leeway and some solace that in fact they can use their judgment and not be concerned about what a prosecutor might say. Was that necessary? How likely does it have to be that she would die? 50%? Can you show me proof? That's what this is about.
And conversely then, if a doctor is supposed to be empowered by this to make their own judgment, could doctors be prosecuted federally if they're in one of these states that has banned abortions with no exceptions, and then they don't perform one in a situation like complications from pregnancy loss, from miscarriage, which may not be as clear-cut as an ectopic pregnancy?
Well, this law doesn't provide the basis for prosecution. The remedies that the federal government could pursue is fines against hospitals or doctors who do not do something that in their medical judgment they thought was necessary. Or they could take away Medicare funding from the hospital. But what the clarification makes clear as well, and that's always existed, is that individual patients can bring individual lawsuits saying that you have a standard of care, doctor, that you needed to follow and you didn't follow it in my case. And so the patient could then raise the federal law and say, and I showed up in an emergency room and you didn't follow your medical judgment and do an abortion when it would have protected me.
Thank you so much for joining us this morning to talk about this new wrinkle. We know things really haven't changed in California, but this will potentially change the landscape with this reminder that has been sent out by HHS about this new landscape that we have when it comes to abortion across the country. Thank you so much.
Happy to be here. It's all very complicated.
Yes, it definitely is, and we appreciate your insight always. Time now.